My name is Chuck Canterbury, National President of the Fraternal Order of Police, the largest law enforcement labor organization in the United States, representing over 327,000 officers. I'm here this morning to urge this subcommittee to pass H.R. 413, the Public Employer-Employer Cooperation Act. The legislation, which is co-sponsored by nearly 200 members of the House, was considered and overwhelmingly passed by the last Congress. Its enactment is one of the highest legislative priorities of my organization. It's a very simple bill, crafted to accomplish a very simple objective: to give our nation's public safety officers who put themselves in harm's way every day the opportunity to sit down and talk with their employers about workplace issues. It's about the importance of dialogue between the rank and file public safety officers and the agencies that employ them. This bill would recognize the fundamental right of public safety employees, primarily law enforcement officers and firefighters, to form and join unions and bargain collectively with their employers over wages, hours, and working conditions without undermining existing state labor laws. The FOP believes that the federal government has a legitimate and even vital interest in public safety, even at the local and state level, because all of these officers are an integral part of our national security and our ongoing efforts to protect the United States from domestic and foreign terrorists. Congress routinely sets minimum expectations and requirements that must be met by state and local governments to achieve a federal objective. I would also remind those who would conjure up the boogeyman of collective bargaining having an adverse effect on public safety that every single police officer in Pennsylvania, New York, and Washington, police and fire, who responded to the terrorist attacks on September 11th were covered by collective bargaining agreements. Just recently, the 2 Pentagon police officers that prevented disaster by subduing the shooter at the Pentagon are members of an FOP labor union. None of those called to action in these most extreme of circumstances paused to contemplate whether any of their actions would impact current or future negotiations. Collective bargaining is a critical tool to resolve differences, not create them. The bottom line is not a shareholder profit versus wages, but how to best keep the public safe and to get the officers safely home at the end of their shifts. The success of the law enforcement mission depends on an open dialogue that is absent in far too many of our departments today. When the bill requires an impasse resolution mechanism, I do not expect that impasses will be common, but rather they will be rare. It has been my experience that labor and management can resolve their issues if they have a means to discuss them. Imagine for a moment how difficult it would be for Congress to conduct business if there was no way for the leadership and the party members to caucus and plan their party's agenda, or if there was no dialogue between the majority and minority members. If this were the case, bipartisan agreement would be even less possible. There would be no way for Congress to function. H.R. 413 would require the right of employees to form and join a union, the requirement that public safety employers recognize the union and agree to bargain over hours, wages, and terms and conditions of employment, and the availability of an impasse resolution mechanism such as fact-finding or mediation. These are minimal requirements at the heart of this legislation, and none can be fairly called burdensome. I want to emphasize very strongly that this legislation is constructed in such a way that it preserves and protects the authority of the state to maintain and administer its own collective bargaining laws. The legislation presumes that states are in compliance unless the FLRA finds otherwise. I'd also like to note that the legislation protects state right-to-work laws and would allow states to enforce laws that prevent employers and unions from requiring union fees as a condition of employment. I know that the National Right to Work Committee is an influential and well-funded organization, but having read their criticism of this legislation, I have to tell you that they're far off the mark. Forced unionization and helping union bosses corral more members goes beyond political hyperbole. It's irresponsible, offensive, and it's just wrong. Mr. Chairman, this bill takes a minimalist approach to a critically important issue. It's well-crafted, balanced, and respectful of the principles of federalism. I urge this committee to pass this bill on to the full committee and subsequently to the floor, and let's get it to the Senate. Thank you, Mr. Chairman.